This webinar, as you know, has been jointly organized by the Milan Bar Association and the Law Society of Hong Kong. Of course, we cannot overstate the role that these two organizations play for practitioners in their respective jurisdiction. They support lawyers throughout their careers, from training to providing continuous legal education, and of course, organizing joint events. The reach of these organizations is significant. The Bar Association of Milan alone has over 25,000 lawyers. And one of the fundamental goals of both associations is the internationalization of their activities, as they strive to create a strong relationship aimed at increasing the exchange of knowledge, mutually assisting their members, and generally facilitating the circulation of truly global, diverse, and inclusive legal culture. The diversity of our legal tradition is an aspect of strength on which we would like to build an increasingly closer relationship. So today we have an incredibly prestigious array of speakers lined up. Before introducing them, I note that we will have a Q&A discussion at the end of the panels. So everyone, please feel free to put any questions that you may have in the chat using the chat function in your Zoom application during the webinar. And without further ado, I'll introduce and then pass the floor to Mr. Chan and Mrs. Zanazi for their welcome remarks. Mr. Chan is the president of the Law Society of Hong Kong. He serves on a number of statutory bodies and has practiced law advising high net worth clients and corporations in relation to their asset management, trust, succession, and tax planning matters. He is also a legal advisor to different family offices for prominent families, and is now a general counsel of an investment company and a part-time consultant at a local law firm. Ms. Zanazi is the chair of the Foreign Affairs Committee of the Milan Bar Association and a member of the Council of the Milan Bar Association. She's also an established lawyer in Milan, and she's the founder and managing partner of IFL, International Family Law Firm. Ms. Zanazi's practice focuses on all areas of family law, inheritance law, and wealth management, and she's also widely published in legal journal, and she's also a lecturer for specialized masters and professional courses at various universities in Italy and abroad. So I'll leave the floor to Mr. Chan and Mrs. Zanazi. Thank you.
Thank you. Ms. Francesca Zanazi, Chair of the Foreign Affairs Committee of Milan Bar Association, distinguished speakers and moderator, members of the Law Society of Hong Kong and the Milan Bar Association. Good day, or good afternoon, good morning, depending where you are from. It is my absolute pleasure to welcome you all to today's joint webinar. Exploring business opportunities for members is an important task of the Law Society of Hong Kong. Over the years, we have established extensive connections with legal professional organizations in various jurisdictions, laying a good foundation for collaboration and activities that are beneficial to the respective members. The pandemic has brought a near halt to international travel and most of the physical activities over the past 2 years. We've just talked about the travel restrictions and booking hotels in Hong Kong. Fortunately, with the help of technology, we are able to remain connected, unhindered by geographic separation. It is indeed encouraging to know that around 180, 190 members are joining us today to know more about the challenges that companies in Italy face when accessing Hong Kong's capital market, as well as the opportunities for Hong Kong companies to invest in Italy. We are happy to reconnect and foster our bonding with our Italian counterparts since the Memorandum of Understanding signed between the Law Society of Hong Kong and Milan Bar Association back in 2014. Before giving the floor to the speakers, allow me to briefly introduce the bilateral trading relationship between Hong Kong and Italy and the Hong Kong legal system. When we talk about Italy, you will probably think of its food, wine, football. Like I said, I'm a fan of AC Milan, fashion and luxury brands. In fact, Italy is a close trading and investment partner of Hong Kong. On the trading front, Italy was Hong Kong's 4th largest trading partner, fourth largest export market, and the third largest import market in the EU in 2020. As for bilateral investment, Hong Kong was the third largest destination in Asia for Italian investors in 2019. For the same year, Hong Kong investors also made substantial investment in Italy, with the city ranked as the fourth largest Asian investor in the country. As a leading international financial center, Hong Kong is one of the world's best places to do business. Our free trade policy and simple and low tax regime make it easier for businesses and companies to operate. Our strengths are well recognized internationally, as shown in numerous international rankings where Hong Kong stays on top. For instance, Hong Kong was once again named the world's freest economy in Fraser Institute's Economic Freedom of the World since 1996. In addition, Hong Kong was ranked 5th globally in the World Competitiveness Yearbook 2022, published by the International Institute for Management Development. Under the principle of one country, two systems, Hong Kong has a well-established legal system firmly based on the rule of law and independent judiciary. On the one hand, Hong Kong is part of China. On the other hand, Article 5 of the Basic Law provides that the socialist system and policies shall not practice in Hong Kong. And Hong Kong's previous capitalist system and way of life shall remain unchanged for 50 years after the handover, or 2047. As you may have noted from the news report, we have just celebrated the 25th anniversary of the establishment of the Hong Kong Special Administrative Region last week. In particular, President Xi Jinping reiterated that the success of implementation of one country, two systems means that the system shall be maintained in the long term, and there is no reason for change. Further, in explaining the direction of one country, two systems policy, President Xi Jinping reassured the importance of maintaining the unique advantages of Hong Kong, including its common law system and judiciary's exercise of its power independently in accordance with law. Being the only common law jurisdiction within China, the tried and trusted legal system of Hong Kong is always a cornerstone of our success. Hong Kong's open door policy has successfully attracted legal talent from around the world, enriching the diversity of our legal services market. As of the end of June 2022, there were more than 11,000 Hong Kong practicing solicitors and around 940 local law firms, as well as roughly 1,500 registered foreign lawyers from 33 different overseas jurisdictions and 81 registered foreign law firms in Hong Kong. And for today's purpose, there are actually 8 foreign lawyers and 2 law firms coming from Italy, and we want more. What's more, Hong Kong is a natural dispute resolution venue with world-class arbitration and mediation institutions that are capable of providing efficient and reliable dispute resolution services, such as the Hong Kong International Arbitration Center and the International Chamber of Commerce. Robust legal infrastructure and financial system, well-regulated markets, business-friendly environment, a deep pool of liquidity and talents, as well as close cooperation with mainland China, have made Hong Kong an important gateway for foreign investors to enter the markets of mainland China, especially the Guangdong, Hong Kong, Macau, Greater Bay Area, as well as a connector between the East and West. So please enjoy the rest of the webinar, and I hope that you will find the event informative and fruitful, and would be interested in investing in Hong Kong and Italy. Thank you for your kind attention.
Thank you, Mr. Chen, and I'll leave the floor to Ms. Francesca Zanasi. Thank you.
Thank you, Riccardo. Thank you. Dear Mr. Chen, dear colleagues and friends, it's on behalf of the board of the Milan Bar Association and its president, Vinicio Nerdo, And on behalf of the Milan Foreign Affairs Committee, which I preside, it is a great honor and privilege for me to welcome you all today at our seminar. The seminar jointly organized by our law societies on ensuring effective capital market access, Hong Kong and Italy. Since 2020, COVID has impacted our business, professions, and society at large. We are now emerging from that period of time, I hope, and confronting our profession with the challenges of living and working in the so-called new normal, which is affecting the legal profession as well. During the pandemic, we have been capable to transform these challenges into opportunities, strengthening our networks and broadening our reach. The International Foreign Affairs Committee of the Milan Bar Association has remained at the center stage of this historical change. We have been evolving and adapting as we navigate online meetings and international interactions. During the last 2 years alone, the International Foreign Affairs Committee of the Milan Bar Association was able to organize a huge number of digital conferences, webinars, discussion panels, and programs to the benefit of thousands of attorneys in Italy and abroad. We were able to leverage the challenges related to the impossibility of meeting in person and expanding the international cooperation, achieving solid results across a spectrum of areas. The Milan Bar Association and the Hong Kong Law Society have been cooperating since 2014, when they signed the Memorandum of Understanding to work more closely together and for the benefits of their members. I met the Hong Kong Law Society and its old president, Mrs. Melissa Pang, for the first time in April 2020, when I had the honor to attend as a speaker the roundtable Resilience through COVID-19 organized by the Law Society of Hong Kong via Zoom. We were in the middle of a pandemic crisis, and yet we were there telling each other our stories, which was really important. So my gratitude today goes to Mr. Chan, the president of the Law Society of Hong Kong, and all his staff, as well as all to the speaker and to all members who are all contributed to organize this amazing conference. So thank you, and I wish you all a great work.
Thank you, Ms. Danasi and Mr. Chan for your insightful remarks. And I believe that this leads us into our first session of today, which will focus on the Italian perspective on today's topic. Our speakers today are two expert practitioners. Our first speaker is Marco Marazzi. Mr. Marazzi is a partner at Baker McKenzie and has been practicing law for over 26 years. And he focuses on corporate and commercial law as well as M&A. Mr. Marazzi has been involved in a number of cross-border investment projects in Italy, China, as well as Southeast Asia. Mr. Marazzi is fluent in Mandarin and has also been very active in advising European and Chinese clients on private and public M&A transactions. He is also a board member of the Italy-China Foundation and a board member of the Italy-Hong Kong Association. Our second speaker is Mr. Ludovico Rusconi. Mr. Rusconi is also a partner at Baker McKenzie in the Banking, Finance, and Securities Department in the Milan office. Ludovico's areas of practice comprise transactional banking and securities. He has long-standing experience in assisting Italian and foreign banks and corporate clients in structuring, negotiating, and executing various types of financing transactions, as well as in capital markets transactions. So I'll leave the floor to Marco Marazzi. Thank you.
Well, thank you everybody. I think I will start by giving an agenda of what we're going to talk about. The first, I'm going to put into the, the economic, giving an economic background of the trade and investment relations between Italy and Hong Kong, a little bit deeper than what our previous speaker, foreign investment restrictions, which are something we have to take into account, which did this, at least this level until 3 years ago. And then my colleague Ludovico is gonna follow up with the rest of the companies. Well, first of all, we talk about FDI stocks, right? Because here we're talking about investment more than trade. Now, it is true that Hong Kong is a very important investment destination for Italian companies. The numbers are taken from the Bank of Italy, statistics, and we see that outward FDI stocks to Hong Kong are very high. We're talking about 3 billion, more than 3 billion in 2019, and 2020 more than 2 billion. There's less investment coming from Hong Kong into Italy. Now, Hong Kong is always a very interesting place to do statistics about, because you never know actually how much capital is coming from Hong Kong itself or is rerouted through Hong Kong from different regions. But as you can see, there is room for growing FDI from Hong Kong to Italy. In terms of like exported imports, as my previous speaker mentioned, there's been a lot of exchanges between, a lot of trade between the two areas. Of course, again, Hong Kong is not only a destination market, it's also a market, the goods get there and then is re-exported. And the same, the goods that come from Hong Kong into Italy, they may be coming from different countries, coming from mainland China, maybe coming from other countries. So, but if you look at the statistics from 2019, 2020, 2021, Italy has actually a surplus with Hong Kong, which is interesting because with China as a whole, we have a deficit. So we are importing from China much more than what we export to China, but we are exporting to Hong Kong much more than what we import from Hong Kong, even taking into account the re-exportation. Next slide. If you look at what we are importing from Hong Kong, it is obvious that, you know, the lion's share is telecommunication and equipment. Then we have optical goods, electrical apparatus, jewelry, and pearls. So these are the main imports. The main exports from Italy to Hong Kong are, as you can expect, travel goods, handbags, jewelry, footwear, the typical fashion articles, perfumery, textile fabrics that are, a solid export of Italy. So I think the relationship is pretty strong. There is a lot of interest in developing further trade and economic relations with Hong Kong. I can tell you that Hong Kong is still perceived as a very free economy, and I never end to stress this to Italian investors that Hong Kong is one of the freest economies, if not the freest economy in the world, in terms of like easiness of setting up a company, easiness of doing trading. It's a number of criteria where it doesn't really compare with the rest of Asia, including China. It's much more difficult to do business in mainland China. So it's I think we have room to grow. And I think what we would like to see more, however, is Hong Kong direct investment into Italy. And that's why this seminar, we will talk about the capital markets as a possible investment destination. So I hand over to Ludovico to present the Italian Stock Exchange, and then I will follow with the next topic.
Okay, thank you, Marco. Good morning and good afternoon, everybody. So what we're going to do in this second part of the Italian presentation is to give a kind of overview of the Italian Stock Exchange and the main aspects that are to be considered for a company willing to list on the Italian Stock Exchange. So first, okay, so essentially one perhaps things that you all know is that starting from 2021, Borsa Italiana, which is the Italian Stock Exchange, has become part of the Euronext European platform, which is one of the biggest stock exchange in the European region. Borsa Italiana has currently diversified structures in terms of offering for markets. They essentially have 4 regulated markets, and in addition to that, 6 multilateral trading facility. The most important one for, I would say, traditional issuers like corporates is the Euronext Milan, which is the current name of the former main market named as Mercato Telematico Azionario. The main requirements to list on the Italian regulated market, and we will focus on the Euronext Milan because, as I said, is the is the most important one for corporates, is we have provided in this slide a couple of key information, is a minimum of 40 million market cap and with at least 25% free float. Interesting to say is that the main market, the Euronext Milan, has a sort of special segment for companies which are willing to have a particular visibility on the market. And this special segment is named Star. Now, the Star is a part of the Euronext Milan, but it requires more stringent requirement, and particularly they require an higher free float, which is 35%. Other requirements, minimum requirements to list on the Euronext Milan is at least 3 fiscal years of published financial statements. Sometimes the Italian Stock Exchange may grant exemption from those. And the other important thing is that the most recent financial statement, both statutory and consolidated, must be fully audited. We have a concept where if the company or if the issuer is the result of extraordinary transaction or other transaction that has had an important impact on the financial composition or structure, the stock exchange also requires that pro forma statements are produced. And there are also some particular requirements for issuers that are not established in Italy, so they are not Italian incorporated entities. In that stance, so non-Italian incorporated entities can list on the Italian Stock Exchange, but in that case, there are some additional requirements in terms of evidence of corporate structure and corporate organization that has to be provided to the competent authority, which is the Borsa Italiana. Now, listing in terms of documentation, the listing process of in Italy basically pivots around 2 key documents. One is the prospectus, the listing prospectus, which is fully harmonized because we have all across Europe a uniform legislation, which is normally named as or known as the EU prospectus. The EU prospectus is basically regulated by a regulation of the EU Commission that identifies precisely the type of information that is required to be provided in order to make a listing or a public offering within all the EU countries. And the other key documentation is, of course, the documentation that has to be produced to Borsa Italiana, which is the listing application and specifically relates to the sort of history and the prospects of the applicant listing entity. Key actors in the listing process are essentially 3 sponsors, typically banks. A sponsor is, apart from very limited circumstances, but mandatory in order for Borsa Italiana to authorize the listing of a company. And then we have these 2 authorities, which is Consob, who's responsible for approving the listing prospectus, and then Borsa Italiana, which is the company owning and organizing and managing the stock exchange. Timing, okay, we have indicated this timing of 5 to 6 months. This is actually the realistic timing to complete a listing. I mean, that is to say, I mean, Borsa Italiana has a statutory period of time where they are required to approve or reject the listing application. And the same thing is for Consob. Reality is that each authority has the opportunity and the right in certain circumstances to basically suspend the relevant timing if they believe that the information provided is not complete. So in reality, the real timing considered is suspension and integration of documentation that normally you have to consider if you want to list on an Italian regulated market is 5 to 6 months from the kickoff. That basically includes the due diligence process, the drafting of the prospectus, the authorization of the consul, and most importantly, the authorization of the Italian Stock Exchange. An aspect that I wanted to mention here, because this is something we have been requested recently, particularly a couple of times to address, is whether the Italian Stock Exchange recognize the concept of the cross-listing or a simplified way of listing for companies that are already listed on other regulated markets. Now, reality is that Borsa Italiana has not a special procedure for companies listed in other regulated markets. So the only advantage of being already listed relates to the prospectus side of the transaction. And by the way, it is limited exclusively. So in fact, this is not very helpful unless that a company is already listed in an EU regulated market or in another market which is specifically recognized by the Italian Stock Exchange or the Italian Consul, which are quite a few for the time being. So essentially, if you are a company listed in another regulated market and you want to cross-list on the Italian Stock Exchange, at the end of the day, the process is more or less the same as doing a full listing. The only advantage is that you may have a simplified prospectus to think about. Other aspect that, and now I will pass again the floor to Marco, is the foreign investment restriction, which may have an impact on the listing process. So Marco, please.
Yes, well, the world has changed a little bit since April 2020 for Italy, at least for foreign investors in Italy. I hope you can hear me well. What happens is that Italy has always had, since 2012, some restrictions to foreign investment in certain sectors. In 2012, we were talking about mainly infrastructure, energy, defense, telecommunication. These were very, very broad categories, but the number of transactions affected were very, very little. And those rules applied also to investment by EU companies, not only by companies sitting outside of the EU. Now, what happened in 2020, there's been a revolution. In April 2020, after COVID, the Italian government, together with other governments in Europe, felt that there was a need to protect from takeover by foreign companies, also other sectors. So what happened is that in 2020, there's been a huge broadening of the coverage of these rules. What do these rules provide? These rules provide for a mandatory suspensory foreign investment screening. That means that if you want to buy shares of an Italian company, and it applies even if you buy more than 10%, which can be very little, you know, if you buy more than this share and you're one of this sector, you cannot avoid to submit a request for approval to the government and notification, and the government will review it from a perspective of national security, public security, national interest, and safe functioning of networks and their procurement. They will review this proposed investment or acquisition, and they will issue an opinion about it, or they will not issue an opinion, in which case, if within 45 days you don't hear from them, you're basically clear. What are the sectors covered? As I mentioned, originally, we were talking about defense, homeland security, energy, transportation, and telecom sectors. The new sectors are healthcare, food security, water, banking, finance, insurance, any dual-use product, information technology, critical technology, sensitive information, including personal data. Particularly the last one can be quite troubled because a lot of companies right now handle personal data. It could be a video game company, maybe, or where, you know, you subscribe and you provide your data. It could be, you know, a subscription TV provider. It could be any sort of company right now handles large amount of personal data. Now, if I choose or any control even more shares in, you may have to go through the process. This has nothing to do with antitrust. It's totally separate from antitrust. And thresholds could be a EU level or Italian level. That's always been around. This is new. In 2020, there is this new procedure you have to go to evaluate where the investment to the Italian economic security, basically. What are, okay, well, there is any direct or indirect, you know, share transfer is basically caught. A merger is caught. It's still not clear, although the answer probably is no, whether greenfield investment are caught, but it depends on what greenfield investment you're doing. If you're setting up a company and buying all the assets of another company, that's caught. Or if you're setting up a company and then buy some, you know, even technology or production asset from another company, even not all of them, to you know, sort of like carry out your business, you could be caught. But the most obvious is a share transfer, share acquisition. And that's, I think, what is causing a lot of problem for a lot of, you know, investors, because you need to take that into account. Even technology transfer could be caught. As I mentioned, the government has 45 days to clear, to veto or impose any obligation on the transaction. So far, since 2020, when the new rules came up, there have been only 6 veto, and the transaction notified have been maybe close to 1,000. So it's not been a lot of vetoes. And there's been many more situations where conditions were imposed. That we haven't counted them, but there are more. Even projects we handled. Conditions could be, for instance, if the company is handling some personal data, you have to ensure complete separation between the management of these data carried out in Italy and any possible leakage of this data to the country of investment. Now, you have to understand that the geopolitical issues also play into that. If the buyer is a German company, the Italian government will be brilliant in reviewing the application. If it's, a Chinese company, they will be more careful. And as a matter of fact, the transactions which have been vetoed are mostly concerning foreign investment coming from China, and especially SOEs. So you have to take that into account, that, you know, the world has a little bit changed, and traditional Chinese SOEs cannot just come to Europe, and because these rules also apply in Spain and other countries, and just buy up whatever critical technology or any company in the critical sector they would like to buy. There's going to be a scrutiny, and the government is going to decide whether this is good or bad for the country. Now, the outcome of the review, as I mentioned, could be veto or any specific undertaking. And the undertakings are monitored, okay? So if you get clearance based on this obligation to do certain things, the government is going to monitor later whether you have implemented this Don't underestimate the need for this approval. There was a case 2 years ago where an Italian, company in one of these sectors, and they failed to do the notification. The transaction has been caught the government found out about this, and there have been also penalties for the parties involved, which sometimes are very heavy. So let's go ahead with the slide. I hand over to Ludovico.
Okay, thank you, Marco. So going back to the key aspect to be considered for companies to be listed in Italy. Now, one of the other aspects important, absolutely important, is indeed the corporate governance structure. Corporate governance in Italy is very much regulated, and a substantial part of the corporate governance rules are sort of derived from EU directives that have been implemented over the time. So in this respect, the corporate governance system in Italy tends to mirror the corporate governance mechanism that you can find in other companies within the EU framework. Essentially, the core of the corporate governance system pivots around two general concepts. We have a bunch of mandatory rules that every company is legally required, as insofar it is listed in Italy, to comply with. And then we have a separate set of voluntary rules that are mostly codified in a code of corporate governance, which is a document produced by the Italian Stock Exchange. These rules are voluntary in the sense that no company is legally required to abide to them, but there is a legal requirement whereby if you decided not to follow these rules, you are required to explain the reason why you're not willing to comply, which is the US derivative principle, the comply or explain. Now, in terms of mandatory rules, we have summarized here the most important one. Those are essentially eligibility requirements for directors and auditors. They must satisfy certain honorability, professionalism, and independence requirements that are set out by the law. There are also limitations on the possibility for directors to hold simultaneously offices in different listed companies. This is because there is a general principle whereby if you're willing to hold an office within a listed company, you are supposed to have the time to do sufficient time to devote to your role. So if you're holding too many offices, this does not work. We have a gender diversity principle, which has been recently amended. Now it is required that the less represented gender within the board of directors must be obtain at least 2/5 of the members within the relevant board. We have, of course, the disclosure of substantial shareholdings, that is to say, shareholders holding a participation in excess of a minimum amount of the share capital are required to report their shareholdings at the time they buy it, or in subsequent installments, depending on which threshold they overstep. We have the voting list mechanism, whereby the board of directors and the board of statutory auditors must be appointed by way of a listing vote mechanism that basically enables minorities to appoint at least one member of the board and one member of the board of statutory auditors. We have the obligatory presence of the external auditors that are required to audit the financial accounts. And one other important part is that there is this very specific committee that must be established within the board of directors, which is the Related Parties Committee. So it is a committee required to specifically screen and in certain cases approve all transactions with related parties that the issuer may decide to interact with. On the voluntary rules that are those spelled out in the Code of Corporate Governance, we have various aspects that are addressed. Most importantly, those relates to the fact that there are some committees that Borsa Italiana requires to establish, which are essentially the Remuneration Committee, the Internal Audit Committee. And in this respect, Borsa Italiana has devised over the time very specific requirements to ensure independency of the relevant members. Other important functions that are sort of recommended by the Code of Corporate Governance is the establishment of an internal audit function, a lead independent director in the case that the CEO is a substantial shareholder, so just to avoid conflicts. And another important thing is the fact that companies are required or sort of requested to develop specific remuneration policies to remunerate their top managements and top directors and managers. Now, on the ongoing obligations, as every listed company is required to do in almost every listing venue, there are a number of ongoing obligations. These are, we have sort of prepared a kind of selection. These are most notably the obligation to public financial statements, annual and semi-annual, for entities listed on the STAR segment, which we spoke about before. There is also the requirement to public quarterly financial statement. We have a very, very robust, which is derived by the EU legislation, market abuse and disclosure of inside information legislation. This is mostly, as I said, derived from a regulation, so it is a consistency applied across all Europe on the basis of this market abuse regulation. We have the obligation to disclose significant transaction, that is to say, transaction that has a particular impact on the financial statements, financial conditions, or economic condition of the company, must be disclosed to the market with a specific information document. We have, of course, rules on internal dealing, and we have these two reports that are required to be prepared every year, and more or less at the beginning of the calendar year, which is a report on corporate governance that basically describes if and to which extent the company has decided to meet the requirements of the Code of Corporate Governance on the basis of the comply or explain principle we said before. And we have this other report on the remuneration policies, that is to say that a company is required to disclose to the market how they basically remunerate the directors. One important thing is that in Italy, there is this very specific requirement that is not in Italy, actually, it's all across Europe because it derives from a directive, that the remuneration of the top management must be sort of distributed between variable remuneration and fixed remuneration, so that essentially directors are more kind of stimulated to work for creating value for the stakeholder, and the variable remuneration in this respect is a key driver to ensure that. One very last comment, just to stay within the strict deadline we have been given. ESG compliance. Now, ESG is a very important topic over the last couple of years, and is becoming more and more important. The Italian Stock Exchange, as far as other stock exchange in Europe, is investing a lot in terms of creating specific indices that basically tracks a listed company which invest or that sort of shape their business or organization model across or around ESG principle. Important thing that we have to consider, and again, the starting point is a EU directive. We have this non-financial statement. The non-financial statement is essentially an additional document that a company listed on an Italian regulated market is required to provide. And it is basically an analysis. It is technically should form part of the report of the management on the financial statements. In fact, in most of the circumstances, is a total separate report. And this report basically gives is meant to give a very detailed analysis of here we made essentially the summary of the scope of this financial statement, is basically to deliver and explain how the company is considering and is organizing its activities in terms of environmental, social, employee matters, respect of human rights, anti-corruption, and bribery matters. Now, in practice, this ESG compliance report over the last couple of years has a more and more very strong focus on sustainability and green aspects or environmental aspects, which are becoming more and more important. in connection with the development of the non-financial statement, one thing that has been sort of naturally, in a sense, developed in the organization of Italian listed company is the ESG Committee. ESG Committee is not required neither by the Code of Corporate Governance, but over the last couple of years, more and more companies are voluntarily establishing this committee that basically has the function of monitoring all the ESG aspects that the company is required to comply with, and is specifically focused on those aspects. As I was saying before, the Italian Stock Exchange is recognizing the importance of ESG matters. They have established the Borsa Italiana a new specifically index, which is called the MIB ESG, and this basically selects the 40 biggest Italian issuers with more than 1 million market cap, which are showing the best ESG practices. Now consider that because now Borsa Italiana is part of the European Euronext platform, this is the second ESG index launched by Euronext. The first one was made in March 2001, and it was in France, is the CA40 ESG. One thing just to mention for completeness, the ESG theme is very important, and there is now a proposal of the EU Commission, well, actually it's 1 year ago, but the proposal is to basically further enhance and strengthen the commitment of Italian listed company towards sustainability. And this proposal of directive is basically to create a new layer of information and commitment towards delivering information on ESG practices, but most importantly, evidence of how the company is investing and keeping the track with ESG, particularly in order to make investors and other stakeholders being very well aware of how the company is moving. And with this, we have completed our overview of the Italian Stock Exchange.
Moving now on to our next panel, let me introduce you to Miss Olivia Khan. She's one of the founding partners of Wellington Legal, and she has worked widely in the United States, in the United Kingdom and Hong Kong. Her practice focuses on litigation matters, covering a wide variety of areas, including complex property ownership disputes, contract disputes, director and shareholder disputes, and insolvency and bankruptcy. Ms. Kong is a member of the Hong Kong Institutes of Arbitration and an arbitrator of the Guangzhou Arbitration Commission. And she's also an adjunct professor at Beijing Normal University. Ms. Kong, you have the floor. Thank you so much for being here today.
Thank you. May I share my PowerPoint with everybody here? Right. Right, I'm going to talk about Hong Kong side. We have just listened to the Milan side. So one thing to confess, I am not a capital markets lawyer. So I'm going to set the scene for my colleague, William, who's going to speak later. I want to show you this picture. So when you think about Hong Kong, what do you think? I bet it's Kung Fu, movies, shoppings, nice nightlife, Lan Kwai Fong, the bar place, rugby sevens, good food, dim sum.
Dim sum.
Yeah, dim sum is great, isn't it? Nice, busy place, right? So it's actually more than that. Now, I just give you some basic facts and figures of Hong Kong. And as you can see from the map, we are a little dot there. So we are 7.5 million population, and which is the 4th most densely populated places in the world. We are a city and a special administrative region of China. 3rd in the Global Financial Census Index and 4th on the UN Human Development Index. We are one of the world's freest economy, according to the Economic Freedom of the World Index 2021 by Fraser Institute. And we also ranked 7th competitive economy by World Competitiveness Ranking 2021. So this is our little trophies, okay? This, I think not many of you do know, is the brief history of Hong Kong. I would like to just give everybody a very, very brief history of Hong Kong. Hong Kong used to be a very small little village, and China lost the first Opium War against Britain, and the Treaty of Nanjing was signed in 1842. Hong Kong Island was ceded to Britain. Now, after the loss of the Second Opium War, Convention of Beijing was signed in 1860. Then Kowloon Peninsula was ceded to Britain. The Second Convention of Beijing was signed in 1898. Kowloon Peninsula, the north side of Boundary Street, and the new territories was leased to Britain for 99 years until 1997, the famous year. Hong Kong was occupied by Japan during World War II, and British administration resumed after World War II. In 1984, Britain signed the Sino-British Joint Declaration with China, and Hong Kong was handed over back to China on 1st of July, 1997. Now, why I want to tell you all these is because there is something called one country, two systems, which I think a lot of you have heard about. So what's this? It's actually a principle proposed by the Chinese leader Deng Xiaoping during negotiation with the British Prime Minister Margaret Thatcher over the expiration of the UK's lease on the new territories of Hong Kong in 1997. Now, the principle is basically Hong Kong can retain its established system under a high degree of autonomy for up to 50 years after handover to China. And the principle has been implemented through the Basic Law of Hong Kong, which served as a mini constitution of the region and consistent with the Sino-British Joint Declaration. And this is our law today. Hong Kong is responsible for its domestic affairs, including but not limited to the executive, legislative, and judicial power. And these powers are devolved from the Central People's Government under Basic Law. So why pick us? Because of the unique history, which I've mentioned to you guys early on, we are a place where the East meets the West. Hong Kong has a significant location advantage. Traveling to mainland China is very easy. And also to most of Asian destinations as well, is about 5 hours flight. So a high-speed train connects Kowloon Station in Hong Kong with Shenzhen in mainland, and it only takes around 20 minutes traveling time. So it's super fast. We have a free market economy, international financial center, simple and low tax regime. Now, I have lived in the UK for 20 years, and to me, this is heaven, okay? No VAT. Free flow of capital, free trade, level playing field for foreign and local companies, no barriers to trade, and no estate tax. So why not? Capital markets specifically. So why list in Hong Kong? As of the end of 2021, the Hong Kong Stock Exchange is the 7th largest in the world by market capitalization. We have a very well-developed capital markets. Hong Kong has a very well-developed capital markets, and companies listed in Hong Kong have access to numerous financing options. It helps companies grow their businesses and expand into new markets. As I mentioned just now, we have a strong legal system. And companies listed in Hong Kong are subject to high standards of corporate governance to protect investors. And like us, we are well-educated workforce. So companies listed in Hong Kong have access to a platform of talented employees, and it can help companies expand their operations and grow their business. So one thing I do need to point out is Hong Kong, most people can speak English because it's actually in the education system. So it should not be a problem language. Greater liquidity. Hong Kong is one of the most liquid equity markets in the world. Investors can buy and sell shares quickly and at low cost. This liquidity is a major draw for companies looking to list their shares here. And of course, the city is beautiful and we have well-developed infrastructure. We have got efficient stock exchange, reliable telecommunications, and deep pools of capital. It ensures companies listed here have access to the necessary resources to grow your business, and diverse investor base. So we have got institutional investors, pension funds, retail investors, individual investors. And so it ensures companies that list here have access to a very wide variety of investors. I want to show you this video because I think nothing can beat a video actually produced by the Hong Kong Stock Exchange themselves. So let's watch this.
HKEX is Asia's global marketplace. What does it take? Connectivity. When people, markets, capital, and ideas all come together to create opportunities. And as we celebrate our 22nd listing anniversary, we're pleased to open our newly renovated Connect Hall, further enhancing connectivity as we build the marketplace of the future.
22 years ago, Connect Hall was home to Hong Kong's live trading floor. Today, it is an iconic and inspiring venue, rooted in history, built with sustainable materials, and equipped with the state-of-the-art facilities, where communities, partners, and colleagues can come to connect, share, and collaborate.
Connect Hall is a space where we can celebrate Hong Kong's history as an IFC, and a destination where we can look to the future and the many opportunities ahead. We're looking forward to welcoming you here, as together we build the marketplace of the future.
So it's a very good video, and I watched it and I thought the buzzing. I can feel the buzzing here. So this is an extract from the Hong Kong Stock Exchange website. I think I'll read this out because it's actually quite important. We are extremely proud that Hong Kong has ranked as the world's #1 IPO venue in 7 of the last 12 years. This success in attracting global issuers and investors is testament to the opportunities available in Asia's most dynamic and vibrant capital markets. In 2020, a total of 154 companies raised Hong Kong 398 billion, the highest amount raised in a single year since 2010. And despite recent global market volatility, our primary market continues to take a leading position in the world's IPO fundraising league tables. In April 2018, we introduced new chapters to our listing rules, for the first time opening doors to pre-revenue biotech companies and new economy companies. Since then, we have welcomed 128 new economy companies, including 28 biotech companies and 10 secondary listing companies together, raising a total of 554 billion Hong Kong dollars. Following Alibaba's successful 101 billion listing in 2019, we continue to attract some of the world's biggest IPOs and new economy companies into our market. In 2020, we welcomed the listing of JD.com, JD Health, NetEase, and Yum China, just to name a few. We remain focused on enhancing our processes and market infrastructure to make Hong Kong and Hong Kong Stock Exchange an ever more attractive listing venue for companies from Hong Kong, Asia, and around the world. So this is from the Hong Kong Stock Exchange website, and you can explore more if you're interested. Now, basically, I'll give you a very brief overview of the boards you can list in Hong Kong Stock Exchange. There's the main board, that's a market for more established companies that satisfy our financial and track record requirements. Companies listed on the main board include conglomerates, banks, property developers, to internet companies and healthcare providers. So it's a very wide variety of companies. Issuers can choose to list in the form of shares or Hong Kong depository receipts. And there is a board called GEM board, GEM. It's a market for small and mid-sized companies, and it's less stringent eligibility criteria, but similar continuing obligations as the main board. So now I would like to talk briefly about this issue. Lots of people actually ask this question. So is Hong Kong actually competing with Shenzhen and Shanghai in terms of the growth in the capital markets? So I actually saw this news from South China Morning Post the other day. It's actually an interview with John Lee of UBS. So in his perspective, the competition is always positive and is always a catalyst to create more market interest. So he said, I have been asked this question a lot. Will Hong Kong be replaced by Shenzhen or Shanghai? And have been asked that question for a number of years. But what you have seen, especially in the past few years, despite the growth we have seen from Shenzhen and Shanghai, the Hong Kong market has continued to grow. And in fact, the Hong Kong stock market has now become the sort of international gateway for a number of Chinese companies. And we have seen more and more of these A shares and X shares type of listing, where the company, they would list their domestic shares in Shanghai or Shenzhen and list their overseas international shares in Hong Kong via the X share regime. So in fact, the development of all three markets, again, has been a win-win situation for all of them. And therefore, this is the answer to the question lots of people has been asking us. Another question, which is actually very popular, is the US-China war and the US sanction. How is this impacting on our Hong Kong capital markets? Now, I want to give you a very brief background. Prior to the enactment of the HFCAA, lots of Chinese companies chose to list as primary listing in the US and use Hong Kong as a secondary listing only. On 18th of December 2020, the Holding Foreign Companies Accountable Act, which I've just mentioned is HFCAA, became law in the US. And among other things, the statute requires the US Securities and Exchange Commission to identify public companies that have retained a registered public accounting firm to use an audit report where the firm has a branch or office that located in a foreign jurisdiction from US, and the Public Company Accounting Oversight Board has determined that it is unable to inspect or investigate completely because of a position taken by an authority in the foreign jurisdiction. And as you can see from the list, if you go onto the website of the HFCAA, there's a whole list of companies that they are not happy with, and a lot of them are from mainland. So since the enactment of this act, many Chinese companies now choose to do dual primary listing in the US and Hong Kong, and some even forgo the primary listing in the US, for example, Alibaba. So they only go and list in Hong Kong instead. So some even choose to unlist in the US and only do primary listing in Hong Kong, like China Mobile and China Unicom. So for us, Hong Kong, we are actually benefiting from this, this war. So that's the answer to some common question that lots of you will have to people in Hong Kong, especially the capital markets lawyer. But I'll just give you a brief answer and I'll pass it to my colleague, William.
Thank you, Olivia, and thank you also for putting today's topic into an historical context. I found it extremely enlightening, and I think that you make a great ambassador of Hong Kong around the world. So our next speaker is Mr. William Ling. Mr. Ling is the founder of Ling & Lawyers. For many years in his early career, Mr. Ling had a private practice with some of the largest international law firms, both in Shanghai and in Hong Kong, principally focusing on areas of capital markets, M&A, commercial matters, covering a broad range of industry sectors. William is also an expert on China-related investment and trade matters and served for years as an now senior legal counsel to a prominent Fortune 500 corporation headquartered in Europe. Additionally, William was an executive director and general counsel of a Chinese company listed on the Hong Kong Stock Exchange. You have the floor. Thank you.
Thank you very much, Ricardo. All right, good afternoon if you're in Hong Kong, and good morning if you are still enjoying your cappuccino, the authentic Italian style. Thanks to Olivia for your nice introduction to Hong Kong. So we can right now take a closer look at our capital markets because we only have 20 minutes or so. So in Hong Kong, as mentioned, we have the main board and the growth enterprise market, GEM. As of the 30th June, so that's end of last week, we have currently more than 2,200 companies on the main board, whereas we have 345 on the GEM board. And then the market capitalization of Hong Kong's main board is about 40 trillion. So if you use today's rate of exchange, that's about €1 to 8 Hong Kong dollars. So there will be roughly 5 trillion euro. Well, the euro has weakened a bit against the Hong Kong dollar because the Hong Kong dollar is pegged to the US dollar. And we all know the US dollar has gone strong recently due to their interest rate hike. And then as you can see, the market cap of the GEM board is relatively small. It's only about 94 billion Hong Kong dollars. So the GEM board is really small compared to the main board. And actually, the liquidity is quite low. So in that sense, I would say the GEM board is not really a precious stone of the Hong Kong Stock Exchange. So the holy grail or the real precious stone is the main board. And that poor performance, I would say, of the GEM board does not defeat the glory of the main board, which constantly ranks within the top 5 in the world in terms of market capitalization and in terms of the amount of IPO funds raised. So in order to list on the main board, you can meet a number of financial requirements. And one of the most commonly used one is the profits test. So for that, you should have at least 35 million Hong Kong dollars for the latest financial year. And then in the 2 preceding financial years, you need to have in aggregate 45 million Hong Kong dollars. And then if you want to come to Hong Kong for a secondary listing, you need to have a track record of 5 years and the minimum market capitalization of 3 billion Hong Kong dollars. So if you want to come to Hong Kong for a secondary listing, one of the requirements is that you need to be a recognized stock exchange of the Hong Kong capital markets. So the good news is Italy is a recognized stock exchange. So that means the companies listed in Italy can come to Hong Kong for a secondary listing. And for the GEM market, the financial requirement is relatively low. Basically, there's no profit requirements for GEM listings. All you need to have is a 2-year aggregate operating cash flow of 30 million Hong Kong dollars, and then have a market capitalization of 150 million Hong Kong dollars. And by the way, you cannot come to Hong Kong for secondary listing on the GEM board. And you probably don't want to go there anyway for the reasons that I have just mentioned. So this is a quick IPO process. You start by appointing professional parties, and just like the case in Italy, you appoint a sponsor, which is typically an investment bank. And then you will, of course, appoint lawyers advising on various jurisdictions, maybe Italy, Cayman Islands, Hong Kong, PRC, whichever jurisdictions that may be involved. And then you'll probably appoint accountants, auditors, valuers, industry experts, etc., etc. And then after that, of course, all parties start preparing for the application. So you would do financial reports, you would do due diligence, you start preparing the prospectus. And first milestone, and that is the submission of the formal application, or we call it the Form A1. And then there will be a vetting process by the stock exchange. So that's basically multiple rounds of Q&As. So the stock exchange will be asking questions, and then you'll be answering questions and keep revising your listing documents and prospectus. And then after that, there would come the second milestone, which is the listing hearing. So the listing committee of the stock exchange would decide on your case. And if you're lucky enough, you can pass the hearing, and then you can go on a roadshow to try to sell the company's shares to investors, typically institutional investors. And then after that comes the happiest moments of commencement of trading. They used to be really happy back then, a few years back, because the market was good. And then typically shares could rise perhaps more than 50% on the first day of trading, and sometimes we even double the price. But right now, the market, as we know, is not as good, so they are not as happy these days. In terms of timeline, the answer is really all lawyers' favorites. It depends. So it depends on the scale of operation of the company. It depends on the nature of business. It depends on how prepared the company is when they submit the application and all that. So generally, we're probably looking at 6 to 9 months for a standard one. In terms of fees, you have multiple items to spend. So probably the biggest one would be the underwriting commission. Of course, that goes to investment banks. And then on top of that, they also charge you a fee for their services. And then there are exchange trading fees, SFC transaction levy, and FRC levy. But these are, I would say, relatively insignificant. And then you will need to pay a brokerage, that's typically 1%. And then, of course, there are legal and other professional fees, accountants' fees, printing and other expenses. So again, the total fee really depends, but you can easily look at tens of millions of Hong Kong dollars and sometimes up to 100 million Hong Kong dollars or more. So after the happy moment of commencement of trading, again, you are subject to post-listing compliance, just as in the case of Italy. So you are subject to listing rules, takeovers code in Hong Kong, and the company's ordinance, the Securities and Futures Ordinance. Just like the case in Italy that we have just heard, you will need to disclose financial statements. You will need to disclose anything that is significant to your business, to your financials, to your board of directors, etc., etc. And the major regulators would be the Hong Kong Stock Exchange, of course, which is basically the equivalent of Borsa Italiana. And then we also have the Securities and Futures Commission, which is perhaps the equivalent of CONSOB. I'm not going to pronounce the full name in Italian because I cannot. So there are actually some special features of the Hong Kong Stock Exchange. So one of that is China Connect, which means that we Hong Kong investors can actually buy shares that are listed on the Shanghai Stock Exchange and on the Shenzhen Stock Exchange, respectively. And vice versa, mainland investors can buy shares that are listed on the Hong Kong Stock Exchange. So this is what we call Stock Connect. And actually the Connect mechanism extends to bonds products. And beginning early this week, the Connect mechanism also includes exchange traded funds. So as you imagine, this is actually an additional layer adding to the broad investor base of Hong Kong's capital markets. And then we have the so-called weighted voting rights. What it means is really one share will carry more voting rights than other shares. So basically you have two classes of shares. Traditionally, Hong Kong Stock Exchange did not have that. So when China's e-commerce company Alibaba sought a listing in Hong Kong a few years back, they couldn't do it because back then in Hong Kong, one share must only carry one vote. So after that, Hong Kong revised its rules and right now it's possible. So as in the case of Alibaba, I think a bunch of about 30 people holding less than 10% of the shares in Alibaba actually have the control of the board of the company. And we also have a relatively new regime since 2018, and that's the pre-revenue biotech companies. So these companies do not meet the financial requirements that I have just mentioned. These are particularly designed for biotech companies. As we know, biotech companies, it may take a long time for them to do their R&D, for them to go through multiple stages of clinical testing, for them to commercialize their products and to generate revenues and profits. So it takes a long, long time. So the idea is really for them to have access to the capital markets so that they can have funds and money to do what they need to do. And then also a very, very new regime is the Special Purpose Acquisition Company, or SPAC. So as we know, this has been a hot topic globally, especially in the US. We didn't have this until this year. And actually the first time a Hong Kong government official said about this was only last year in March. So when the financial secretary said Hong Kong would explore the regime of a SPAC, it was in March last year, and then within 6 months, they already rolled out a consultation. And then they had a consultation conclusion in December last year. And guess what? We already had the first SPAC company listed in Hong Kong in March this year. And just last month, we already had the second SPAC company listed in Hong Kong. So I think this is another example of how quickly the Hong Kong Stock Exchange can change and adopt to the latest trends, or even leading the trend. So let's take a look at overseas issuers. By overseas, I mean any jurisdiction other than Hong Kong. So traditionally, Hong Kong accepts Cayman Islands of Bermuda, which are common law jurisdictions, right? And then since around 2000, there was an influx of PLC companies coming to Hong Kong. So they either restructure themselves as Cayman or Bermuda companies, or they could directly list their shares in Hong Kong. And we call those shares H shares, and H stands for Hong Kong. And of course, right now, Italy is an accepted overseas jurisdiction. So what that means is, in principle, Italian companies can come to Hong Kong to list. And of course, this is a good news for our Italian friends. So there are some key requirements for listing overseas issuers in Hong Kong. And all these three requirements apply to all overseas jurisdictions. So the first one is you need to have some sort of international cooperation arrangements with Hong Kong. And the second one is you need to have a shareholder protection level that is at least the same as that in Hong Kong. So if your particular overseas jurisdiction has a shortfall in terms of shareholder protection, then what you need to do is to amend your constitutional documents. So in the case of Italy, perhaps bylaws or articles of association in other jurisdictions. And then in terms of financial reporting and auditing and tax, then you need to have some sort of reconciliation with the Hong Kong standards, or do some sort of disclosure in your listing documents or prospectus. Now, let's study the case of Italy in terms of these three core requirements. So in the case of Italy, CONSOB, or the Securities Commission of Italy, is a full member of the International Organization of Securities Commissions. Okay, so in addition to that, CONSOB also has entered into a MOU with the Hong Kong SFC. So basically, Italy meets this international cooperation arrangement requirements, and this is primarily for the purpose of exchanging information between the two jurisdictions and for enforcement purposes. Now, this is straightforward. So in terms of shareholder protection, now let's take a few examples. So one example is that Hong Kong requires that reasonable notice be given to shareholders for shareholders meetings. Then on the one hand, Hong Kong law says that you need to have 21 days for annual general meetings and then 14 days for other general meetings. On the other hand, in Italy, so Italian law requires that you need to give 15 days of notice to shareholders for shareholders meetings. So in this case, Italian companies will probably need to amend their bylaws to meet the requirement of the Hong Kong notice requirements. Another example would be Hong Kong requires that given the rights to attend, speak, and vote at general meetings. Now, of course, under Italian law, shareholders have that kind of rights. But then, as I understand, for Italian general meetings, shareholders cannot give their proxies to directors or employees of that particular company. Whereas, on the other hand, in Hong Kong, we do not have that kind of restriction. So naturally speaking, you probably need to amend your articles as well. But the good news in this case is that the Hong Kong Stock Exchange has actually accepted this difference. So they say this difference is immaterial. So basically, you don't need to do anything about it. Okay. So a third example is the so-called dematerialization risk. So what that means is really Italian law may require that share certificates cannot be used as evidence to show title to the shares. Now, currently, I understand that the Italian law does not require this dematerialization being applied to Italian companies listed in Hong Kong. But then there is a risk that this Italian law may apply in the future. So what Italian companies need to do is to make a disclosure in the risk factor section of the prospectus or elsewhere in the listing documents. Now, in terms of financial reporting on auditing, in Hong Kong, we use the Hong Kong Financial Reporting Standards and International Financial Reporting Standards. And then in terms of audit, we use the audit standards published by the Hong Kong Institute of Certified Public Accountants, or that under the International Auditing and Assurance Standards Board. So in the case of Italy, you guys will probably use the IFRS as endorsed by the EU, and then use Italian auditing standards. So the good news again here is that the Hong Kong Stock Exchange accepts these two standards, but then this is on the precondition that there needs to be a reconciliation statement. So you need to say the material differences that you adopt that particular set of standards. Of course, thank God, we lawyers do not need to care about such reconciliation statements, and we can leave it to the accountants. So in terms of taxes, in Italy, as I understand, you have dividend tax, you have capital gains tax. So when the Italian company pays out dividends, so they basically need to withhold a certain portion for dividend tax. And then when you sell your shares and make a profit, then you need to pay capital gains tax, and you need to do a tax filing for that particular purpose. And there will be financial transaction tax in Italy. As you can see here on the slide, there is nothing on the Hong Kong side, and this is not a typographical error. This is because Hong Kong does not have dividend tax, and we also do not have capital gains tax. We have some sort of transaction tax, and that is called stamp duty. But again, in my opinion, that's relatively low. It's only about 0.13%. And then we generally do not need to make any specific tax return for our investments in the stock exchange or the capital markets. The good news is in 2005, Italy actually entered into an avoidance of double taxation treaty with Hong Kong. So the implication is that for Hong Kong investors investing in Italian companies listed in Hong Kong right now, you don't need to pay capital gain tax. And for that purpose, you don't need to make any tax filing. But of course, as a prudent lawyer, I will add a disclaimer here, I'm not a tax advisor, so investors should consult their tax advisors before investing in Italian companies listed in Hong Kong. So let's look at a couple of real-life examples. Actually, there are currently 2 Italian companies listed in Hong Kong. So one of them is Prada. It listed 11 years ago in 2011. Its stock code is 1913. And guess why that's 1913? Because Prada was actually founded in 1913. So its listing was perhaps a good news to ladies, because ladies could own stocks in Prada in addition to their collection of handbags and shoes. It was actually a successful IPO at that time. So Prada raised about $2.14 billion US. And then there was no listing of Italian companies in the past 10 years or so until earlier this year in March. We have Ferretti, and Ferretti is a leading manufacturer of super yachts. So I think this time is a good news to gentlemen who would want to own shares in a super yacht company. So there is no Italian company listed in Hong Kong in the past 10 years until Ferretti. Actually, a lot of things changed during this 10-year period. The Hong Kong Stock Exchange actually revised their listing regime for overseas issuers. So right now, the regime is more transparent, is clearer, and is more streamlined. And then what is clearer right now is that Italy is right now a so-called acceptable jurisdiction, because actually when the time product got listed, there was no such clear guideline. So I think at the time, Prada actually had to apply to the stock exchange for a listing decision to ask them whether an Italian company could list in Hong Kong. So right now it is pretty clear that yes, Italian companies can come and list in Hong Kong. And then another change that happened was the double taxation agreement that I have just mentioned. So back then when Prada was listed, investors in Prada will probably need to pay capital gains tax if they make a profit out of buying and selling Prada shares. But right now, because of this avoidance of double taxation treaty, if you buy shares in these companies and make a profit, then you don't need to pay capital gains tax. So again, let's go back to why these companies come to Hong Kong. I didn't make this up, okay? Ferretti said this. So I didn't want to trick their wording, so I'm just using their wording. So Ferretti says they come to Hong Kong because they want to become a real international company, leveraging one of the largest and most visible stock exchange markets in the world. And to expand the business worldwide, especially in the Asian markets, and to increase the diversity of investor base and have more liquidity, and to enhance the company's profile and reputation as well as visibility. So, the last company that I want to mention is a company called Milan Station Holdings Limited. This company is not based in Milan, okay? It's not even an Italian company. This is a relatively small company operating about 14 boutique shops in Hong Kong, Macau, and the PRC, selling second-hand handbags and stuff like that. Okay, so again, it's a relatively small company. But I mentioned this company because this company actually listed in Hong Kong about a month before Prada did. So that's also in 2011. Now, this company, although small, their IPO was actually very successful because their IPO was oversubscribed by over 2,000 times. Okay, that's 2,000 times. And their share price rocketed by more than 60% on the first day of trading. So what I'm trying to say here is that just the word Milan might give you significant share price premium, because at the time of the listing, according to the press, many public investors thought that Milan Station is actually a company coming from Milan, while the reality is that no, that's not a Milan company. So that concludes my presentation. So my dear Italian friends, please tell your clients to come to Hong Kong. We have a huge pool of legal talents in Hong Kong, including, I think, more than 150 joining us today, who stand ready to serve you and your clients. So thank you for listening and for your patience. Ciao.
Thank you, William, for your extremely interesting contribution. And I'd like now to open the floor to questions. Our panel discussion and Q&A will be introduced by Mr. Amirali Nazir. Mr. Nazir is Vice President and Chairman of the International Legal Affairs Committee of the Law Society of Hong Kong. Mr. Nazir has been involved in various Law Society committees since 1995 and has been Vice President since 2016. Mr. Nazir is the founder of Nazir Solicitor, and his main areas of practice are litigation, company law, commercial law, Islamic finance, property, trust, and notarial services. I'll leave you the floor. Thank you.
Thank you very much. We've actually got a number of questions on that. Perhaps we can, maybe I can take one for Olivier. You mentioned a lot of advantages of listing. Before I go to William, you want to mention some disadvantages listing?
It's Olivia. Yes, I did.
Go ahead.
Do you mean listing in Hong Kong or in Italy? in Hong Kong.
No, Olivia, this in Hong Kong, first. I'll come back to you, Marco. Come back to you as well.
Yes, I did mention all the advantages of listing in Hong Kong, but in fact, we are perfect. We have no disadvantage. No, I'm kidding. There are some disadvantage, or you say the cons, okay, of listing in Hong Kong. And some people think it's quite heavily regulated. And so companies will need to jump through lots of hurdles and in order to list here. Now, it's yes and no, because as I have mentioned and William has mentioned as well, Hong Kong, because the Hong Kong Stock Exchange is actually quite vigilant in actually making sure the company is okay before they can list to the stock exchange, and they need to protect the investors. So therefore, obviously, they will need to do quite a lot of vetting and verifications, et cetera, and asking questions to make sure this company is okay, it's what it is, and before they can actually list on the stock exchange. Another thing is some people think Hong Kong is has got quite a volatile market. Yes, but at the same time, it actually shows that it is actually an efficient market, because some markets, for example, in renminbi, they have got a control of 10% ups and downs. So in Hong Kong, we don't. So it actually reflects the real market and how people react to announcements, et cetera. As we have mentioned previously as well, Hong Kong is a free market, and that's why it will have these issues as well. Yes, another thing is William mentioned about Milan station. I was actually in that deal. So yes, it was a fun deal to do, and drafting the prospectus was also very fun. But yes, I can confirm that company is not a Milan company; it's a Hong Kong local company. And Prada, can I just say something? I have seen the Prada prospectus. The cover is amazing. It's just beautiful as usual. So yes, I'll leave the floor back to Amirali.
Oh, thank you, Olivia.
Can I add something
Marco,
to what
yes,
Olivia? Can I add
do.
something to what Olivia said? I mean, of course, we made an introduction about listing.
You're breaking up, Marco.
Unless you have a very, very, very solid. Hello?
Yeah, you broke up there.
Can you hear me?
No,
no. Unless you have a very solid investor at your back, and in the case of Ferretti, was a Chinese company controlling the shares. And unless you're really committed to really face all the difficulties in listing in Hong Kong, is not a proposition for small companies looking for, or mid-sized companies looking for to access to capital markets in Asia. I think it's really a challenge. As you've seen, only Prada and Ferretti are being listed in Hong Kong. But of course, it's a great avenue to tap into the capital markets, very deep capital markets of Asia, and actually have a lot of Asian invest in Euronext, exchange. So I think this is, but again, just be prepared, because I mean, not every Italian company could actually be capable of doing something like this. Okay.
Yeah. But it is open so long as you comply with the regulatory requirements. Then it is a very good place to access Asia's market.
Yes, it is.
William, how about using the Hong Kong Connect? How can a Italian company use Hong Kong Connect to its advantage?
Well, you can hear me, right?
Yes, William, I can.
Well, sure. So if you come and list in Hong Kong, and then if you are eligible for the Stock Connect, then mainland investors will be able to invest in your stocks. So there is a minimum requirement of 5 billion Hong Kong dollars in terms of market capitalization, which actually is not that big, I would say. And then if you are one of the constituent index components, then you would be eligible for that sort of stock connects.
Right. Ludovico, do you see any companies that would be interested in the Hong Kong Connect?
Well, no, unfortunately for the time being, not yet. And
Okay.
perhaps the reason is essentially for what Marco just said, is because, I mean, for the time being, the Hong Kong Stock Exchange is viewed by, say, Italian company, well, by very big Italian companies as a potential venue. So, and most importantly, also the level of knowledge of the stock exchange is still to be rebuilt. By the way, this seminar was extremely interesting from, let's say, an Italian investor side, because also for ourselves, we got a couple of insights that we were not perhaps so much aware, and definitely sort of may help investors who could be reluctant because they do not know the legal system now
Yes.
to think in a different way. But indeed, there is some education to be able to sort of foster and increase the interest and the access to that market by big companies in a way.
I mean, the Law Society allows foreign lawyers to work in Hong Kong. So Italian lawyers can come to Hong Kong, set up a firm,
Yes, sure.
within firms. And, you know, there would be a huge asset to Italian companies wishing to go through the maze of regulatory loopholes that William has identified. But clearly, I'm not sure whether Italian companies will take advantage of the tax incentives that William has identified. I mean, it's zero tax as far as comparatively. And of course, the huge advantage for Italian companies is Italian companies in Hong Kong and Italy in general have a huge reputation, a mass that already exists here. You know, it's mass in brand and mass in value. And that's something that is very difficult to develop if you go to another country. And that's something that can actually be leveraged on, and you don't actually have to put in resources into that. As you can see, William quite clearly identified a company just used Milan. I mean, it's passing off, but that just underlies the huge reputational mass, a commercial mass that can be leveraged on. And I'm just wondering whether Marco and Ludovico, you can see how other companies in Italy can leverage on that.
Okay. Well, let me tell you my personal view on that.
Would be good for a leading concept.
So,
Marco, please, go ahead.
Yeah, Ludovico, you go first.
Okay. Now, essentially, what I was saying is that leaving aside let's say the technical orders or the fact that I mean the system may be different, I think that, and this is something that Marco mentioned at the very beginning, the Hong Kong Stock Exchange for the time being could be a reference market for companies engaged in certain types of activities. That is to say, could be, you know, wine, food, luxury, because there is a strong market in the Asia area where the brand and the product may sort of gauge interest. Now, as in general, for a company that is not the type of products that are specifically addressed to that market, personally, I think that in this sense, that the competition across all the listing venues could be and will be in most of the circumstances distinguishing and also a guiding criteria. Just to give an example, we are noting in Italy companies that, well, just to give you a little background, traditionally Italian companies have always decided to list on the Italian regulated market. Right. And sometimes I thought about, and they did, to consider the Hong Kong Stock Exchange for those that are sort of in the luxury era, and some of those for some very specific reason, like Ferrari did, the New York Stock Exchange. So these are the main areas. Now, interestingly, what we have been experiencing, and we actually work on this, there are now companies in Italy that are choosing within the EU market not to opt for Italy, but to move in other EU markets,
Right.
which is good because this basically means that there is a sort of change, shift in the thinking that unless that you really want to point to a very specific market like the Hong Kong Stock Exchange for the reason we said, but considering a venue which is not the Italian traditional venue could be good. This is to say that perhaps for the time being, the Hong Kong Stock Exchange is still a market that is perhaps more interesting from an Italian law perspective for companies which work in very specific areas and which have a certain important site. But going forward, I think that the very interesting point that were made, that is to say that the market, the Hong Kong Stock Exchange is interesting because of the market per se, because of the access of the type of investor. So not only for the products, but for the base of investor, is something that Italian companies may start consider over the time. So there could be a change also in the way of thinking. And that's very interesting. It could be an evolution in the way Italian companies sort of put themselves in dealing with a capital markets arena.
Sure. Marco, you were going to say something?
No. I was just saying that, basically, Ludovico has basically said whatever I wanted to say. So that was, it was, a listing in Hong Kong is really fitting for a certain type of companies and which also have a strong shareholder at the back, okay, who is actually also well connected in China or elsewhere, and or they are like companies like Prada, which are famous throughout the world, and specifically targeting that market. So buying shares of a Hong Kong company is different, of a Hong Kong listed companies and story. I saw one of the questions was asking whether I think in Hong Kong the same restrictions to foreign investment that it's in China apply. I think William can reply, but to my knowledge, the negative list of China applies only in China, not in Hong Kong. So that's
exactly.
That means you have more freedom, right, to invest. Yes.
Exactly. That does not apply to Hong Kong.
Yes.
Yeah.
The other thing I'd like to ask William and Ludovico is, would Hong Kong companies or other companies be interested in the stock exchange in Italy, and how would that be possible? What are the advantages there? Looking the other way around. So William and Ludovico.
Well, actually, I'm not quite sure. And actually, I see in the Q&A panel, one of the participants is asking whether there has been any Hong Kong or PRC company that is already listed in Italy. Yes. So I'm actually not quite sure.
Ludovico?
No, to my knowledge, the answer is no.
Right.
The answer is no.
Right.
No.
Okay.
Well, the fact, if I can add a very personal view, sure. I think that the reason for that is that, again, I think that the company and a Hong Kong company that has the opportunity to list in Hong Kong, I wouldn't even understand why they should decide to prefer the Hong Kong Stock Exchange and come to the Milan Stock Exchange, unless that, well, again, add another interesting point, and this is a trend we are experiencing these days. What we are seeing now, and this is the reason why I made a sort of very small remark in our presentation. The interest now is not doing, particularly from Hong Kong companies or companies in the Asia Pacific area, is not to list exclusively in Milan, but there is an increased interest in doing a different transaction. That is to say, to list in Hong Kong and cross-list to Italy. And this is something, well, we've been asked, and we've done a couple of preliminary analysis recently. I mean, something a couple of months ago. That's the interest. So, and this goes perhaps more or less in the way that Olivia was making reference to, that is to say the concept of doing the dual listing, although perhaps for different reasons. But conceptually, the idea is not to prefer the Milan Stock Exchange as the primary listing venue, but as a secondary listing venue. And again, in this case, is to do it basically the other way around. That is to say, of course, you have the sort of Asia Pacific investor base, and then moving also to Europe and try to also ample or widen the base, but on a secondary step, not on a direct step.
Right.
That's the perception we have.
But at least we have some reason for, I mean, there could be commercial reasons, but at least that allows, we're looking at this conference webinar from both perspectives in a way. And so it's interactive. So it's a good thing for members to know. There's one final question, which I can see, which is that Hong Kong exists a negative list for investing in China, FIL law, foreign investment law. You've seen that one, William?
Yes, I think Marco has just answered that question right now.
Right. Okay. Okay.
I replied that. Yes, I already got to that. Okay.
Okay. And there was one about
one thing I may add. One thing I may add is that there might be, I haven't checked, but there might be some companies listed in Milan, which have been listed in Milan for a while, and they have Chinese shareholders, right. So there could have been not a listing of a Chinese company, but there could have been Chinese companies owning shares, even controlling shares in existing listed companies in Milan. I mean, Pirelli used to be one. I think they delisted then, right? They were delisted, but there could be others where there is an interest held by a Chinese investor and is and is a listed company in Milan. So that's
And William, there's also another one says how Hong Kong's contracts stabilize the risk of price spikes for trading materials as nickel. Oh, that's a.
Excuse me, where is the question? Okay.
It's just before the end. It says, how's, it's Annalisa Bolivia, says, how's Hong Kong's contract stabilize the risk of price spikes? So it's 1, 2, 3, 4, 5, 6 above. It's AB.
Excuse me, my screen is not working very well, so I don't really see that question.
I think that's more of a question for a trader than for a lawyer or for an investment banker. I mean, I have no idea how the Hong Kong can stabilize the price of nickel. I don't know whether William knows.
Nickel price stabilization. Okay.
Price stabilization is a bit more difficult. It's quite a complex question to do with a transient, issue. In effect.
Okay, I'm not quite sure if he or she is referring to the circuit breaker that happens to the metal exchange.
Yeah.
That happened some time ago, right?
Yes, that's right. Yeah. That was in the news already. Yeah.
Yeah. Well, that one is really difficult to explain. Perhaps one of the main reasons was really a policy reason, or perhaps they thought it was too risky. Even for the exchange, so they had to, trigger the circuit breaker.
Yeah. Okay. That as Marco said, that's really one for a trader. There's another one, which is the private investment fund market in Italy active? Are Italian investors interested in Asia-focused funds, and how often do Italian fund managers choose to expand their presence to Asia by setting up Asian headquarters in Hong Kong?
So of course there is a private fund market act. It does exist. Can you hear me? Can you hear me well? Yes. Sometimes my connection is not good.
I think it's not Italian investors interested.
Yeah. Are Italian investors interested in Asia-focused funds? I think some of the money that we looked at the beginning, the flows of capital from Italy, which has been more than 3 billion, 2019, over 2 billion, goes into funds. Okay, so it's not going directly into foreign direct investment factories or setting up companies. It goes into funds. There are a number of funds. Asia-focused funds offered by companies, by promoters. In how often do Italian fund managers choose to expand their presence to Asia? That's a more complex question. More than one or two who have actually established offices in Asia. As a matter of fact, the entire Italian finance establishment has been kind of retreating from Asia, closing down offices. For instance, some of the banks have closed down offices in Singapore or Hong Kong simply because it's too competitive. Okay, so in terms of Italian managers setting up Asia, I'm aware of two of them, one in Hong Kong, one in Singapore. I'm aware of trying to cooperate with local, fund managers rather than setting up a presence directly. But definitely there is money going into funds.
Sure.
Okay.
Okay, I think we've come to the end of our panel discussion, and we must now move on to the closing remarks. So I'd let Ricardo introduce.
Yeah, actually the closing remarks are up to you, Nazir. You can go ahead. Thank you.
Okay, so I'm as chairman of the International Legal Affairs Committee, we encourage the contact between different bar associations, and we're very delighted to have cooperated with the Milan Bar Association today on this very interesting topic. We hope that we can deal with other topics as well. I'm very grateful for the time and effort put in by our president, Francesca Zanassi, who's the chair of the Foreign Affairs Committee of Milan Bar. Marco, you have given us a very interesting outlook on challenges, opportunities. Thank you very much. Ludovico, you've also given us perspectives of capital markets, and I'm sure that's been useful. And Olivia and William have given us the Hong Kong perspective. The idea of this course really is to allow those in Hong Kong to understand the markets in Italy, and those in Italy to understand markets in Hong Kong and the legal and commercial aspects of the two jurisdictions. And only by interacting do we actually learn from each other, and hopefully we can continue with our cooperation with future endeavors. And I thank everyone for participation. Thank you, Ricardo, for dealing with this as an MC.
Thank you. Thank you all for attending, and of course for your time and participation. I think it was a very constructive and productive meeting. And so thank you all on behalf of the Milan Bar Association, and thank you to the Law Society of Hong Kong for setting this up. Thanks to our speaker, and I really hope that in the upcoming months, we will get the chance to finally meet in person. So
Yes.
Have a great day, Milan, or have a good evening if you are in Hong Kong. Thank you, everyone.
Thank you very much.
Thank you. Thank you very much.
Thank you.